Randi, Hyatt, and Garrett Wozniak here from Kollman and Saucier. It is Monday, March 11th, 2019, and Garrett and I are going to spend the next 20 minutes or so talking with you all about everyone's favorite sick and safe leave statute in Maryland, the Maryland Healthy Working Families Act. We decided, given that we're about a year in, that it would make sense to spend a little bit of time updating clients and other employers that are interested about where things are, what we've learned, sort of suffering through figuring out how to manage the statute and apply it to our employees, and also give you some insight and updates about what might be coming down the road from the Department of Labor Licensing and Regulation. We're going to focus in on discipline issues and leave abuse, which certainly are concerns that repeatedly come up from our clients, as well as discuss some potential changes that may be coming down the road. So with that, I'm going to turn it over to Garrett, who can remind us about the statute, what it is, and then we'll dig in.
So in case you've forgotten, the Healthy Working Families Act provides that employees are entitled to leave for a number of reasons, including caring or treating the employee's own injury or illness, the same caring or treating an employee's family member's injury or illness, preventative care, maternity or paternity leave, and then the safe leave reasons are the absences that are necessary due to domestic violence, sexual assault, or stalking against the employee or the employee's family member. And again, as a reminder here, the definition of family member under the Healthy Working Families Act is quite broad. So the scope, if your policies are not up to date, I suggest that you visit our website or revisit the statute to make sure that you're appropriately covering all family members.
Right, because for example, doesn't it includes grandparents and in-laws, which are categories of family members that most of us would not expect to be included based on the Family and Medical Leave Act and other statutes that are out there.
That's absolutely right. And then depending on the size of the employer, the law requires that the leave either be paid or unpaid. If you're an employer with 15 or more employees, you must provide paid sick and safe leave. If you have 14 or fewer employers, you have to, at a minimum, provide unpaid leave. That doesn't mean you can't provide paid leave, it's just the floor is unpaid leave under the Healthy Working Families Act.
So what that means is that everybody gets the leave under the statute. It's whether the leave is paid is dependent upon the size of your workforce.
That's correct.
Great.
So if you have an employee who works in Maryland, the employee is entitled to leave. If you operate in Maryland, your employees in Maryland are covered. But if you operate in Maryland and you have employees in other states who only occasionally set foot in Maryland, those employees are not entitled to leave under the Healthy Working Families Act. And as a general operating rule of thumb, if the employee spends about 50% of his or her time in the state working for you, then you should provide leave to comply with the Healthy Working Families Act. And how much leave do you give? Well, the floor, again, under the law is 1 hour of leave for every 30 hours worked, beginning on the first day of employment. Now, employees aren't entitled to use the leave until the 107th day of employment, but they do start accruing on day one. To refresh your recollection, the Healthy Working Families Act includes a number of caps, floors and caps, I should say. You're not required to allow employees to earn more than 40 hours, which is equivalent to 5 8-hour work days of leave in a year, use more than 64 hours, which is 8 days in a year, or accrue more than 64 hours of leave at any time. And the accrual piece matters when you're talking about carrying over leave from year to year. If an employee has reached the cap, then uses leave in the subsequent year, year two, for example, the employee might be able to accrue additional leave to get back up to the 64-hour cap. So this carryover piece, you must, if you go on the accrual method, whether as long as you're meeting that floor of 1 hour of leave for every 30 hours worked, and like accrual system, you must permit your employees to carry over leave from 1 year to the next. The only way you're not required to permit employees to roll over the leave from year one to year two and so on is if you front load the leave at the beginning of the year. So if you provide 40 hours of leave, for example, at the beginning of the calendar year, on every January 1, you need not let the employee roll over whatever he or she has left from December 31 to January 1, because on that January 1 they're going to get their new allotment of leave. And covered employees. So this is one of the areas in which the Healthy Working Families Act doesn't really give a lot of definition. Employees must regularly work 12 or more hours per week to be an employee under the statute. We suggest that you use a common sense approach. Be consistent. Show that you're attempting or you are complying in good faith. There's an Attorney General opinion that tries to put some meat on the bone of regularly, and what it says is that regularly means usually, ordinarily, or customarily, or normally, which is probably what you would see if you looked up regularly in the thesaurus. The DLLR similarly says that regularly means normal or customary. That may not help entirely, but I think if you use a common sense approach there to determine whether an employee is regularly working 12 hours or more in a week, you'll be in good shape. It's also important here when you're complying with this statute, but also a whole host of others, as we all well know, not to misclassify your workers. Independent contractors are not included in the definition of employee under the Healthy Working Families Act, but you don't want to misclassify your workers, or else this statute will be the least of your worries, and you don't want to have to contact us or anyone else for that matter for a wage and hour issue because of a worker misclassification. Now I'm going to turn it back to Randi, who's going to talk about some other exclusions from the definition of employee and what employers can do here.
Great, thanks, Garrett. So, as Garrett just said, independent contractors, if they truly are not going to be entitled to leave under the Maryland Healthy Working Families Act because they're not going to be a covered employee. There are some additional categories of workers that have been specifically excluded from the definition of employee, and we have heard from a couple of employers out there that there's a little bit of confusion about, who is or is not included in this sort of temporary worker status. So we're going to do our best right now just to hopefully reinforce and remind you what the statute says and how how the exclusions work. So a worker that is employed directly by a temporary services or staffing agency, and that temporary services agency does not have day-to-day control over the work assignments and supervision of the individual, meaning they don't say where they go, they don't say how many hours they must work or must not work, etc. If they just really are giving you a pool of employees to call up and say, hey, I need somebody here today to answer the phones, that person comes in and works, and that temporary staffing agency doesn't tell you, how many days you must have them there, etc., control the hours, that is going to be somebody who is excluded from the employee definition because they're just coming in and filling a spot and they're meeting your needs, you're not meeting their needs. As well as somebody who is directly employed by an employment agency that provides part-time or temporary services to another person. And then lastly, and this really comes in most often, we'll see it specifically in sort of the hospital setting, of course, as it specifically says, it's in the health or human services industry, an employee, a worker who is on an on-call list, if you will, or a PRN or as-needed basis. They're on their list. They're not guaranteed any specific number of shifts or work. The worker is free to say yes or no to the shift. If they want to work, they can. If they don't want to work, they don't have to, and there's no consequence. Those workers are going to be excluded from the employee definition. And again, they're not working for a staffing agency. They're actually sort of on a hospital call list, if you will. Again, it needs to be in the health or human services industry, but that category of worker will be excluded from the employee definition. So next, another sort of hot topic that comes up a lot, and I know when Garrett and I were talking and getting ready for this, we both agreed that most of the calls we get will center around sort of how do we decide use and abuse. So the statute gave us these words that say we can prohibit the improper use of leave as an employer, and we can also prohibit a pattern of leave abuse, but then didn't give us any context to put that in other than, okay, well, how do we define what improper use is? Because that's not covered by the statute or defined further by the statute. And as Garrett will talk about shortly, and you all certainly know, we don't have regulations yet that help give us context. And also the idea that employers are given what seems like some armor or ammunition, if you will, to prohibit a pattern of leave abuse, but there's not much context there. So here's what we do know. So prohibiting improper use of leave, we are allowed to have legitimate rules in place that talk about if you're going to take leave, the kind of notice you need to give. Of course, there's documentation that can be required under the sick and safe leave, which I use to also describe as a shortcut for saying the Maryland Healthy Working Families Act. We can't require that documentation until after the second consecutively missed shift, but we are allowed to say we have rules in place, and as an employer, if we can expect of you, employee, to comply with our rules, and if you're not using the leave consistently with our rules, we are allowed to issue discipline, which is something that we are, whether they can take the leave, but we still are in a position to discipline for improperly using the leave. The other sort of area where as an employer we've got some ability to manage problems is when we have a pattern of leave abuse. Now this is a less foreign concept because many employers that are familiar with and covered by the Family and Medical Leave Act have already been dealing with the concept of what is a pattern of sort of abuse, if you will, of taking family and medical leave. And there, although that is not what is in, it doesn't necessarily govern our Maryland statute, it certainly is insightful where the Department of Labor there has recognized that taking sort of having the Friday, Monday absences happen or absences that immediately precede or follow a paid holiday, if that happens on a recurring and regular basis with a particular employee, that certainly can suggest a pattern of abuse. Or taking, for example, leave on a day for which you've asked for a paid day off and it was denied. That's another example of, does that happen? If it happens one time, I think we'd agree that that's not a pattern. We need to think about what does the word pattern mean? And the word pattern obviously suggests that it's going to happen several times enough that it's not just mere coincidence. Maybe, you flag it so you're watching that person moving ahead, but you've got to see some repeated and regular sort of taking opportunities to use that sick and safe leave if it's available when the leave has already been denied, or again, it's a weekend coming up, a long weekend, that kind of thing.
Or I suspiciously want to try to take leave every time my favorite basketball team is playing during March Madness, right?
There you go. Exactly. Or, if there's as well a pattern of taking leave when the employee is scheduled to do some really high volume work, or there is, sort of a big, sort of less than ideal event going on that's going to require a lot of workers to dig in. Again, one time is not going to be a pattern. Just as Garrett was explaining, how do I define or decide if somebody was regularly working 12 hours a week? Let's look at what makes sense. And, if you had 10 people in a room, would 7 or 8 agree that, we've got somebody who keeps wanting, asking off, gets denied, calls out then and claims sick and safe leave, and they have it available. And of course, it's just a day and I can't get that doctor's note. So you want to, we still are a bit limited in being able to manage it, but let's be vigilant and diligent about looking for that pattern and seeing, hey, this is the third, fourth time that this has happened. I think by then we can feel pretty comfortable that we've got a pattern, and then we can then, with performance management and discipline, do our best to handle it.
Yeah, and I would just add on that, Randy, that when you have an employee who first 10 months of the year, it doesn't miss any time, never gets sick, and that seems to be the employee's MO. And then you have inventory time coming around, and you can use to your point, your common sense to try and pick up on these sorts of things.
Absolutely. And hopefully one day we will get some actual written guidance that will be helpful and give us some better ability to give you all more clear advice in that regard. The other sort of question that comes up often in the context of sick and safe leave, because a lot of employers I have found, get sort of, my word, nervous or worried about denying leave because, it seems like there's this sort of 5 free days out there now that employees must take. And, I know a lot of employers are still sort of working out the kinks because their pre-existing systems, perhaps they had just a paid time off bank. And they didn't necessarily want to carve out, because of sort of the administration process, that just 5 days, and sort of coding it separately, and you're still working through that. So some of you may have employees who are constantly have this very significant bank available that could be sick and safe leave. So, separately, you may want to think about, how has your system worked for you this past year? Are there adjustments that you should or could be implementing that will help it so that you're just talking about 5 days? And then once that 5 days has been used, you then have a lot more flexibility to deny leave, to, focus on those patterns of abuse and whatnot, because then those 5 days are gone with, and then you can actually manage your attendance and discipline a little bit more cleanly without the sort of muddiness of, is this a sick and safe leave situation? Because it doesn't take much for a sick and safe leave to be triggered. I'm sick. My kid's sick. I've got to get to a doctor's appointment. There you go.
And that's a good point about now that we are a year in, looking back and see what's worked for you, what hasn't worked for you. You might find that the front-loading system is not, in fact, good for your workplace. So instead, you want to switch to an accrual, or vice versa. Or you might not have taken advantage of some of the other components of the law that say you don't have to allow employees to accrue leave during certain time periods if they don't work sufficient number of hours. That sounded like an administrative headache a year ago, but now you might find that it's worth it because your leave abuse problem is so substantial.
Great, exactly, right. Because now that you've lived through it a year and you see you've got all these call outs and you're having struggles with getting coverage and then paying other people overtime to work, etc. So with that, just focusing on the denial, and I think we've probably hit these points already. An employer, just to remind you, may deny leave if the employee doesn't provide notice and the absence will cause a disruption to the employer. And this is a high bar, and disruption does not equal annoyance or frustration, or even, hey, I'm going to have somebody cover their shift, and as I just even mentioned, that person's now going to get paid overtime to cover their shift. That's not a disruption. That's a frustration. But we're talking about true disruption, that you are scrambling to find coverage. You may, in fact, not meet standards if you have them in place as to sort of, for example, in the healthcare industry where you've got to have certain patient-staff ratio needs met, that kind of thing. How disruptive will the absence be other than just being annoyed that it's just an added thing on your to-do list to manage? So assume, again, it's a high bar. As I already mentioned, we can get a doctor's note when the leave was used for more than 2 consecutive scheduled shifts. So that doesn't mean 3. It literally means 2 shifts plus some time into that 3rd consecutively scheduled shift. And if the doctor's note is not provided after that time, you can then deny leave. You also can, if the employee doesn't provide verification and there is a subsequent request for the same reason of leave for which the employee did not provide verification, for which verification was properly due the employer, meaning more than 2 consecutively scheduled missed shifts, you can then also deny leave there. Now, there has been a lot of question, but unfortunately no clarity or answers yet on what is the same reason as leave. Certainly, identically the same reason is clear. Is it the same condition? Is it leave for the employee being sick, or is it leave for the employee being sick for a cough versus leave for the employee being sick because they broke their arm and they're dealing with that for the day? Again, until we have clarity, we're going to go with what makes sense, what sort of seems reasonable. And again, as long as we are reasonable and I think can defend the explanation and are consistent in our application of that across the board, and we're not, unintentionally maybe playing favorites or having certain managers give breaks where others they may not. We just need to be careful in that regard. And then lastly, on denying leave, just a reminder that the Department of Labor Licensing and Regulation has said that if an employee is using leave for an unauthorized purpose or has again demonstrated that pattern of abusing leave. So pattern, we've got repeat and significant number of instances where that leave is automatically being used when no one else seems to be doing it that way. They can then have that leave denied in the future. So just some reminders of sort of the do nots that we all know about, that are consistent with the do nots under pretty much every statute out there that governs the employment relationship and speaks to what an employer can and cannot do. We are not allowed to take an adverse action against an employee for exercising their sick and safe leave rights, and that's going to include discharge, demotion, threatening to discharge or discipline, retaliating in any way. We don't want to interfere with the rights of somebody to take their sick and safe leave. So if somebody says, "Hey, I'm going to need to miss tomorrow. I've got to get my kid to the doctors," sort of that, do you really? Are you sure that's really going to cause me a problem? Remember, next week we're doing your performance evaluation. I mean, even if you let the person go and even if they're not dinged in any way, you want to make sure that you don't have any of those comments or suggestions or sort of frustrated statements made out loud, because that could be construed as an attempt to interfere with an employee's right to take their sick and safe leave. We don't discriminate against employees for their exercise, their good faith exercise, that is, of sick and safe leave rights. Deny them when it's not appropriate to. And we also don't want to implement any kind of attendance or absence control policy that suggests that what is now a sick and safe leave absence can lead to some kind of adverse action against the employee. And the biggest example of that I see in handbooks and in policies that maybe have not been updated is when you say, we reserve the right to get a doctor's note for an absence after a day or two. That is not consistent with the sick and safe leave statute, which says we can't get that verification again until we're into, past that second consecutively scheduled shift absence. All right, now I'm going to turn it back to Garrett, who's going to give us some intel perhaps on what might be coming down the road from the General Assembly.
Yeah, unfortunately, I don't think we should hold our collective breath, because it's unlikely that the General Assembly is going to pass legislation that's going to amend the Healthy Working Families Act and provide the clarification that we'd like. And to Randy's last point, the inability to count sick and safe leave as part of an absence control policy, when it runs up against leave abuse, and that's the question I most often get, is what can I do here? I feel like I'm without a paddle and I don't have any recourse against employees. And so, as Randy referenced, we are still waiting on regulations from DLLR. A year ago, we were told that we could expect them after the election, so between November of 2018 and now. We still don't have regulations, and I don't see any on the horizon. There are a couple pieces of legislation down in Annapolis. There's not a great likelihood that these become law, but here's what they are. One of them addresses the absence control policy. This is House Bill 686, cross-filed with Senate Bill 912, and the Senate version has a hearing on March 19th, so that'll provide an indication on what's going to happen. And that legislation would permit employers to include sick and safe leave use under an absence control policy if certain criteria are met, namely that the employer provides at least 40 hours of paid leave in a year, excluding sick and safe leave. So 40 is the floor, and then you're providing sick and safe leave above that. and the absence control policy is uniformly applied to all types of leave the employer offers, is provided to an employee in writing, and provides a warning to an employee before any possible action taken against an employee. So you're going to follow a slower, a progressive discipline policy when applying this, not a one application of the absence and control policy and the employee is terminated. But that is an avenue that it does provide some recourse. Why is this bill necessary? Well, the bill is necessary because under the Healthy Working Families Act, as Randy explained, you may not apply an absence control policy that includes sick and safe leave absences as an occurrence. But the law says that you may prohibit improper use and a pattern of abuse. So the legislator, that has proposed this legislation wants to resolve this inconsistency. So we'll see. We'll see if the legislation passes. We'll see if the DLR weighs in. We'll see if the Attorney General's office weighs in and resolves this inconsistency. I've heard some say that you may include sick and safe leave as part of an absence control policy, and frankly, that's just not the case based on the way the statute is written. And I think you're treading in dangerous territory if you apply such a policy until the law is clarified. And this dovetails directly into disciplinary policies. So until we know which paths we may follow, do not count sick and safe leave absences as part of an absence control policy. Okay, so that means if you permit 5 absences, your sick and safe leave don't have that be a point on that. Do not discipline if you're using a broader PTO or universal leave policy your employees for the proper sick and safe leave use that is a subset of that leave. However, if there is improper use of leave or the pattern of abuse, you may discipline an employee for that behavior. I don't know unless it's a very serious transgression, I don't know if I would go all the way to termination. I would follow a progressive approach. Again, we reason, we use common sense. But you can take action against employees for improper use and pattern of abuse. And in the model policies, for example, that DLR has put out, they say as much. That's our read here. You can also discipline an employee for not following rules and for dishonesty, separate and apart from an absence control policy. You're not siloed into an absence control policy in terms of this use. And then once an employee has exhausted sick and safe leave, it's fair game, meaning the leave is no longer protected until such time as that employee has earned, accrued, and then uses additional leave under the statute. Another piece of legislation that is being considered in Annapolis is House Bill 56, which would add an additional exemption to coverage of the sick and safe leave law. This bill would exempt from coverage an employee who regularly works at a facility at which the employer offers the employee access to an on-site health clinic, and that health clinic has operating costs of at least $1 million per year and also provides the employee access to discounted prescription drugs. Now, this would apply to larger facilities, I would think in more remote areas that have these on-site health clinics, but also hospitals and other facilities that, as part of their operation, have these clinics built in. Of course, size and scale matters here, and the benefits provided. We'd have to wait and see what the final definitions are and what the iteration of the legislation is, if it's even going to be considered. But that is something that is floating down around in Annapolis. And as we conclude here, I want to turn it back over to Randy, who is going to address just a couple more lingering issues.
Great, thanks, Garrett. So lastly, sort of digging into the substance of the statute, just want to remind everybody and talk a moment about the increments of leave and how that works and how it's managed. So remember, if an employee who is eligible, has the hours in the bank to take and needs to take leave, you cannot Similarly with the FMLA, where you can't force an employee to take more leave than is necessary, under the sick and safe leave statute here, the most that you can require an employee to take is 4 hours. So the General Assembly has said we're not going to give the employer the ability to sort of knock out an entire day, or 20% of that, those 5 days that the employee gets a year. The most you can require an employee to take is 4 hours. Of course, you can also, and many employers do this just because of the way their timekeeping system is set up, you can permit the smallest, you don't have to do 4 hours. You can do it an hour, you can do 15 minutes, whatever sort of your timekeeping system permits, and how you do it is also appropriate. But you can never require more than 4 hours if an employee needs to take sick and safe leave. So if an employee says, hey, I'm going to be out for, an hour or two this morning, I should, their normal starting time is 9. I've got a doctor's appointment first thing in the morning. I hope to be in by 11. If your system is that you always track it at 4 hours, then that is okay, and that's not a violation. But then you want to make sure that you're doing that for all of your employees who are in a similar situation where they only need perhaps 1 or 2 hours. You want to make sure that some are not only having 1 or 2 taken, whereas others are having 4. So consistency is important there. Let's say you have a situation where an employee does call out for half the day, 4 hours, but they only at this point have 2 hours of sick and safe leave available and nothing else. What are you supposed to do? So technically, you give them their 2 hours of sick and safe leave, and then the other 2 hours could be unpaid. Maybe your policy says they're allowed to use, if they have other PTO out there that is, isn't just to be used for vacation, for example. They may be able to have the leave paid based on other existing policies that you have. However, you then can decide, well, what do I do about those 2 hours that quote unquote isn't protected as an absence that for which I may not be able to issue discipline? 2 hours is protected because it's a sick and safe leave. What about the other 2? It's going to, again, depend on your policies. If your policies state that any kind of paid leave that is used consistently with, policy isn't an occurrence under absenteeism, then you wouldn't want to discipline for it. But if you don't have a policy on that, or if your policy is that, hey, if this is not going to be paid or protected leave under an applicable leave statute that we do discipline, you technically do have the right to do that. And you could then decide whether or not that 2 hours of the 4 is an occurrence under your absence control policy. You want to be careful. You want to be careful about that because you want to make sure that and you all probably have dealt with this on one level already, having been a year in already. You want to be consistent. You may have an employee, for example, that this is the first time something like this has happened. They're otherwise they have a great performance history. They have great attendance. They don't indicate any sort of misuse or abuse of leave, including paid leave or leave under the sick and safe leave law. Perhaps they've just had some bad luck the last month and they've had to exhaust all their leave, and now they're at the situation. That's usually sort of the kind of employee that you don't feel compelled to discipline right away. But remember, very likely you're going to have somebody perhaps the next week who maybe you have less empathy for, who perhaps has been a bit more of somebody who uses their leave the moment it's available, maybe has a bit more of a tarnished employment record, so you're not as inclined to be as forgiving. You definitely need and want to be consistent, because then of course you're opening yourself up to accusations of unfair treatment, mistreatment, perhaps discrimination claims, and we don't ever want to do anything in the administration of any of these leave policies that would cause that. So determine what you're going to do, what makes sense given your workforce, your history, your managers. Technically, yes, you can treat those 2 hours that are not covered as an occurrence, and then you need to, I would say, evaluate, your system and your organization and decide what makes the most sense going forward. So some final thoughts from us as we close this out and sort of wait to see what, year 2 of the Maryland Healthy Working Families Act brings. Obviously, questions are going to continue. We still don't have case law guidance yet, which I think is, A, probably a good thing, but B, might take another year or two before some employer out there is willing to be, if you will, a test case on something. As Garrett mentioned earlier, we still do not have guidance yet from from the General Assembly or DLLR, but there are a couple of bills pending, which may give us something from the General Assembly. The DLLR is not necessarily getting out there and putting out for public consumption any updated delivery dates or new promises about when materials may be available to help us all figure things out while we're still kind of, sort of for better or worse, making it up as we go along. But at the bottom line, and I know what Garrett and I have discussed with our clients and others is, what is the focus of the statute? What is the goal of the statute? And let's just keep that in mind, when we make discipline decisions, so that we are not necessarily that test case, and we do things in a consistent and defensible way. And obviously, as things happen, as if there is any new developments, whether from the General Assembly or from the DLLR or otherwise, we'll be sure, through our website and otherwise other communications to keep you all posted.
That's right. And I just wanted to thank everyone for submitting questions. We tailored this presentation to the really good questions that were submitted, so we appreciate you doing that, and we'll keep you posted.
Yes, thank you. Bye-bye.